Unit 7, Lesson 4, the Six-Step Approach, Steps 5 and 6. Hello, everyone, and welcome to Conflict Resolution and Peacemaking, the class that teaches you how to manage interpersonal conflicts and drama for yourself and others. I'm your instructor, David Lowry. We are continuing our discussion of the Six-Step Mediation Process. This simple approach is super easy to learn, highly effective, and used worldwide to solve disputes of all kinds. When you hear about people or groups that aren't getting along, say something like this: I'm sorry for all the trouble that everybody's going through. I've learned some ways to help people settle disputes. If you want, I'd be happy to get everyone together and see what we can do to end this trouble. Our last podcast discussed stages 3 and 4 of the six-step mediation approach. Stage 3 is where you hear the participants' stories about what the conflict is all about. In Stage 4, you begin discussing how you'd like to settle the dispute. This is where bargaining, offers, and counter-offers are made. One side presents an offer for the other to consider, and vice versa. In today's podcast, we will discuss Steps 5 and 6. This is where the best offer is selected and an agreement is drawn up. We will close our unit with a brief discussion of caucuses, or instances where the mediator meets privately with participants. So let's begin with step number 5. Step 5. Select the best solution. It is now time to assist the parties in troubleshooting and reality checking their proposed solution. This is because we know that solutions will likely fail if proper attention isn't given to the details. Our job as peacemakers is to help all concerned plan a course of action to implement their decisions successfully. In Step 4, it's not uncommon for one idea to gain traction and become the de facto solution for solving a problem. However, if more than one solution is under consideration, the peacemaker helps the participants examine the benefits and cost of each, then determines which agreement is best for all. As we do this, we consider an agreement's who, what, when, where, and how. For instance, if ABC Carpet Cleaners agrees to repair a customer's stained carpet, we need to determine the following: who might do the repair for ABC Carpet Cleaners? Number 2, we need to clarify what will be done to repair or replace the stained carpet. Number 3, we must determine when the work will be started and completed. Number 4, we must specify where the work will be done, including what room and what part of the carpet is being repaired. Number 5, we should describe how the work will be done. Does ABC agree to replace the whole room or only a small portion of the carpet? Finally, there are miscellaneous things to consider. What happens if the customer remains dissatisfied? And would it be wise to determine the maximum dollar amount ABC Carpet would be required to spend? Again, our goal is to think about the necessary things required to implement a successful agreement. Reality checking. One of the things that cause agreements to fall apart is when one or more of the participants agree to something that might prove impossible to do over the long term. For instance, a father might agree to visit his son every other weekend, even though his son lives more than 1,000 miles away. Solutions like these might prove difficult for both father and son over the long term. Even though a father appears willing to carry out the agreement, it would be wise to question the feasibility of an agreement that requires either of them to travel back and forth every other weekend. Sometimes what we want to do does not work well with the realities of time, energy, money, and other resources available to us. Thus, our goal is to develop a solution with the greatest possibilities of success. Once the details of a solution are made, the next step is to write a formal agreement. Step 6. Write an agreement. In this last step, the mediator summarizes the agreement and clearly states what each party will do. Next, all parties sign the agreement and receive a copy for their records. Though these agreements do not have the force of law, there is a high likelihood they will work because most parties are usually more than ready to move forward and place their attention elsewhere. And if one party refuses to honor their part of the agreement, they can always seek redress in the legal system. But in most instances, the participants are well motivated to move forward. In alternative dispute resolution programs, such as early settlement mediation, these agreements are called Memorandums of Understanding. Once written, these memorandums are given to a judge for review. If approved, the judge declares the agreement to be the court's order. In cases where divorce or child custody issues may be involved, the agreements are drafted and shared with each party's attorney for further review. If all agree, the memorandum is presented to a judge who reviews, signs, and declares the agreement as the court's ruling. So, continuing with our example of the carpet cleaning company, here's an example of a simple agreement. So, we would head it Memorandum of Understanding, and we would place the date on it, and we would say something like, this agreement is between Jane Jones of 21 Jump Street in Springfield, Missouri, and the ABC Carpet Company of number 10 Evergreen Terrace in Springfield, Missouri. This agreement is a good faith effort to resolve the differences between Jones and the ABC Carpet Company. Jones employed ABC Carpet Company to remove a stain from the carpet in her living area. After ABC applied a stain removal product, the stain became worse instead of better. After participating in a mediation effort, both parties agreed to the following. Number one, ABC Carpet will replace a section of the stained carpet with a new carpet of the same brand, color, and pattern from the front door to the first seam at no charge to Jones, provided the total cost does not exceed $500. Should the cost of repairs exceed $500, the ABC Carpet Company will issue a check to Jane Jones for $500, which she may use to make repairs or other arrangements. ABC Carpet Company will contact the XYZ Carpet Company, also located in Springfield, to repair the carpet within 10 days of this agreement. If the XYZ Carpet Company cannot make the repair, the services of LMNOP Carpet Company will be sought. All repair work should be completed within 45 days of this agreement unless there are extenuating circumstances, such as a manufacturer's delay in shipping materials. Completing the carpet repair ends any complaints and demands that Jane Jones may have with the ABC Carpet Company. Now let's talk about caucus or private meetings. Caucus sessions are private, confidential meetings between mediators and participants, or participants and their advisors. Sometimes during a mediation session, a caucus may be called by either the mediator or participants because of the emotionality of a situation or the complexity of a problem. These private meetings may be called at any time. Other reasons for calling a caucus include the following. One or more participants request a private meeting. A participant needs to quickly check with an advisor before agreeing to something. One party is uncomfortable discussing an issue in front of the other party. A participant wants a moment to think about topics being brought up in the joint session and needs a moment of privacy. Or maybe the participant feels uncomfortable, bullied, or needs a separation. The mediator feels a need to clarify or explore something with a participant that was said earlier, or the mediator worries that the mediation may fail unless a short break is taken to relieve anxiety and tension. Interestingly, private meetings are not called because the mediator feels uncomfortable by the emotionality or reactivity of the participants. Private meetings are ways that mediators serve the participants and not the other way around. When you have a caucus, you need to clarify confidentiality. If a private meeting is required, the mediator leads the participant to an area that affords visual and auditory privacy. The mediator explains that everything being said in the session will remain confidential unless instructed otherwise. The goal is to uncover any hindrances in the mediation process and to discuss how the participant might move forward given the confidential information or the concerns that have been expressed. Remember, what you do for one, you do for the other. When a participant calls a private meeting, it often creates anxiety in the other party. Once the private meeting is completed, the mediator should request that the one who called the private meeting remain where they are while the mediator visits with the other party. Naturally, the other party may be curious about what was said in the caucus. If asked, the mediator should explain that all communications must remain private and that they would like to hear about any concerns they may have. Once the mediator is satisfied that all concerns have been heard, the parties are reunited and the mediation continues. Here's a brief caucus example. Imagine the mediator is talking to Don and Brenda. Brenda has called for a private meeting. The mediator says, I'm going to ask you all to remain here while we go and visit privately. When we finish, I'll come back and visit with you. So Brenda and the mediator go to a private location. The mediator says, Brenda, we're in a room where you can be sure that Don can't see or hear what you have to say. I want you to know that everything you say to me will remain confidential unless you instruct me otherwise. So, what concerns do you have? Let's suppose Brenda wants to tell the mediator, Don is asking for more days with the children, and I don't know how to tell him that I'm moving to another city 2 hours away to take another job. The mediator might say, Brenda, that's a significant thing you and Don should discuss. Of course, you could try and keep this secret, but sooner or later he needs to know about this. What do you think we should do? And Brenda might respond, I could manage to let Don have the children twice a month if he were willing to let me bring the children to him once a month and he came to our new home to get the children for the second visit of the month. So the mediator would then say, Okay, Brenda, it seems like you have a plan. How would you like me to proceed when we get back? Do you want me to say anything? And Brenda says, I'll address this issue once we know what Don wants. And the mediator says, Okay, Brenda, I'm going to ask you remain here while I go and talk with Don. I'll come back to you once we're ready. Now the mediator goes to where Don is sitting and talks with him. Don, I've just spoken privately with Brenda, and now I want to talk privately with you. I want you to know that anything you say to me will be kept in confidence. I won't reveal anything you say unless you state otherwise. Don, what did Brenda say? Is she trying to turn you against me? Mediator, Don, I can't talk about what Brenda said, but I am interested in your concerns about wanting more time with the kids. Is there anything you think I should know about this or anything else before we begin the mediation again? Don, well, I've been seeing a woman named Laura, and I think we may be getting married. If we do, I'd like to keep the kids more often and let them get to know Laura. Mediator. Okay, Don, do you want me to bring this up when we return, or do you want me to keep this to myself? It's your choice. Don, I'd appreciate it if you'd be the one to bring this up and help me over this hard spot. Mediator. Don, I'll be happy to do this once we return. If I understand you correctly, you've been seeing a woman named Laura, and it's getting serious. If you should marry, you would like to keep the kids more often so they can stay at your new home and get to know Laura. Is that right? Don, yes. Mediator, okay, I'll do that. I'll get Brenda and we'll continue with the mediation. As our example indicates, the mediator visits with both people and agrees to keep their confidence. In our example, each person had different requests. One wanted the mediator to hold the information, the other wanted the mediator to broach the subject for him. Some may wonder why the mediator didn't advise Don to wait until he was sure he would remarry instead of bringing up the possibility of marriage. However, the mediator's responsibility is to trust the process and allow each participant the right to discuss whatever they think is essential. Sometimes the mediator might want to offer a small amount of advice if they know the information is vital and must be addressed sooner or later. The fact that Brenda is moving 2 hours away is one of those things. The agreement will most likely fall apart if this information is withheld from her ex. Even so, the mediator is bound to honor Brenda's decision. After all, many people change their minds about taking a new job or moving away, and Brenda might do the same thing. We are now concluding this unit on peacemaking processes that work. We've discussed the direct approach, which is a helpful way of resolving interpersonal disputes, and the six-step mediation process, which one may use to help people in groups arrive at mutually agreeable solutions. We hope you found these approaches helpful. If you use them, you will discover how helpful they can be in bringing peace and safety to yourself and others. We thank you for listening to today's podcast and encourage you to download a copy of this program's transcript so that you might better complete a short quiz over today's presentation.